Okay. Can somebody give a thumbs up if they hear me? This is Jason Novak.
We can hear you.
Yep. Great. Awesome. Okay. Hello. My name is Jason Novak. I'm a partner at Haynes & Boone, and I'm joined today by Gary J. Edwards, also a partner at Haynes & Boone. I'm based out of the San Francisco office, and Gary's based out of the Palo Alto office. We're going to be talking today about IP diligence considerations in protecting your intellectual property. And we're going to be doing it a little differently today. We're going to be talking from what we call both sides of the table. And really what we mean by that is, depending on what sort of stage you are in the company or product lifecycle, we could be talking from an investor, an invested standpoint, from an acquirer and to be acquired standpoint, but from both sides of the table as part of a transaction, whether it be a funding round, whether it be an acquisition or whatever. We're going to be looking at due diligence and sort of looking at it from both sides in terms of what you should be concerned about. Even though you're sort of looking at the same information, you're looking at it from two different perspectives. So we want to examine IP due diligence from both sides, from both perspectives. So today, in terms of an outline, we're going to be splitting this up between defensive IP due diligence and offensive IP due diligence. And we'll get into a little bit more detail, obviously, of what that means. But at a high level, defense is obviously looking at defending intellectual property related issues that can come your way from third parties, whether it be assertions of infringement, in terms of any sort of intellectual property out there that affects your innovation and the direction in which you want to pursue your product development. It's third party intellectual property that may impact your ability to do business. And then in the offensive standpoint, it's your own IP portfolio and things you've done to secure your own IP assets. And that becomes a key part of IP due diligence as well. So we'll get into a lot of detail about that. So really, again, we want to set some expectations here in terms of due diligence overall, in that it's not a certain level of expectation or a certain sort of checkbox list of items. It really does differ depending on where you are, if you're the company or if you're an investor, if you're a lead investor, if you're not a lead investor, if this is a pre-seed round versus a Series C round. A lot of these things impact the type of due diligence that's necessary and the scale to which it's important to the party that's viewing this. So again, there's certain factors that play into this. The type of deal, if it's a merger or a purchase, obviously there's a lot of capital being invested there and you're acquiring some positive and potentially negative assets as part of that acquisition. It could be a simple licensing of IP, licensing the use of some software platform or whatnot. It could be an equity investment from a corporate investor or whatnot, maybe an early stage, a seed round, or maybe even a later round. You could be a lead investor or not a lead investor. It could be also the type of technology that's involved, and depending on the type of technology may impact the value of that IP. Now, traditionally, intangible assets such as IP make up a large percentage of the value of that company. But again, if it's tech versus biotech, the amount of IP, the type of IP may be impacted. You may be more trade secrets if you're in tech. It may be more patent heavy if you're in biotech. So, and it also may depend on how really truly novel your product is, your platform is. That may impact how much IP is available. Maybe you don't have anything really patentably novel, but your brand is valuable. So maybe your trademarks and things like that are more important. So there is no blanket sort of value of IP to the deal as a whole. It all differs. The type of IP differs. So due diligence is always a shifting process. And again, I talked about this before, stages of negotiations impact that in terms of where we are in terms of the round, how much money is being invested, how far along even product development, things like that impact the level of due diligence. The level of risk that can be tolerated, and that is company to company specific. Some companies are very much against accepting any form of risk, and others are willing to tolerate some risk for some advantages in the market. And so that'll impact the amount of due diligence, the level of depth of due diligence, and the expectation on those folks who are actually putting the money on the table. And then finally, where are we in the company or product life cycle? Again, early round, late round, close to product launch, far from product launch, those sorts of things do impact the level of due diligence that may be necessary.
Well, while we're looking at the due diligence on this slide from the investor standpoint, I think that these ideas are things that you should keep in mind throughout development of the IP portfolio in order to prepare for the hopefully inevitability of going through a round of due diligence with a prospective investor or purchaser of the company. And the more you're prepared for that that process, the better and smoother the deal will flow for you.
And that's a great point, Gary. Due diligence, there may be a misconception that due diligence is these types of isolated projects that happen at a certain point in a product development or a company life cycle. It is really particularly for those that are being investigated, for those that are looking for capital for that startup or that company that's growing or is going to be acquired. Due diligence on your IP is something that is an ongoing process that should be consistently relooked at, that you should be relooking at potential third-party IP. You should be monitoring on a regular basis. There's monitoring the ownership details around your portfolio, your patents, making sure assignments are right. So due diligence is, in certain aspects, an ongoing process. There's obviously peaks and milestones as part of that due diligence, and a lot of those are around certain negotiations or funding and whatnot, or certain points in your product lifecycle where due diligence really raises in importance. But it is really an ongoing process, and if you don't do it in an ongoing way, then when you get up to that major milestone point, you're really going to be ill-equipped to be able to handle sort of the needs and expectations of the other side. All right, and real quickly, some risk of inadequate due diligence, and we'll get into how this can happen further on in our presentation. But failure to acquire title to key IP, not monitoring the ownership details, and making sure ownership is properly accounted for so that a transfer of IP can be clean. Exclusive title to key IP versus just title in general. Failure to acquire rights, maybe taking a license to patents, you're not acquiring full rights, maybe there's a joint ownership issue of that IP. So these are all part of due diligence, understanding a lot of that, the ins and outs of the ownership details and the enforceability details and the transferability of IP. Failure to recognize the transaction itself may cause change or loss of key IP rights of the target. That's something to definitely keep in mind. Unwarranted IP obligations on suitors, buying into a lawsuit. These are things that have become part of due diligence. Just because you're acquiring a company, you acquire it warts and all. And you could be buying into a litigation that company may be undergoing or may be soon to be undergoing. And this is, as an investor, as an acquirer on that side, asking those very difficult questions are necessary, because you need to understand everything about what that entity has underneath the hood. And you, as a company that is looking for acquisition or looking for capital, you need to be very transparent about what's underneath the hood. It's very important that you don't hide that because it's a credibility issue. We'll get into more of this as we go on. Okay, so I'm going to tackle the defensive portion of this discussion, which is specifically product clearance and freedom to operate.
Well,
and
I'm on a WebEx seminar right now.
Gary,
yes, sir.
Mute yourself, please. Thank you. So we're going to first talk about the defensive portion of IP due diligence, which is product clearance and freedom to operate. So product clearance. Now, before we get into product clearance, I want to clarify the definition of this. As some folks in the audience may know or can easily determine if they go online and search, the term product clearance can generally encompass FTO or be used synonymously with an FTO. An FTO is freedom to operate. For the purposes of this discussion today, we're going to differentiate a bit what product clearance means. Now, these are just words. I think what's more important to understand is the process and the things that take place as part of the defensive IP due diligence. For the purposes of today, product clearance, an FTO is a part of the product clearance process, but the product clearance process differs depending on where you are in the product development timeline. So, for example, a freedom to operate analysis or an FTO analysis typically happens when a product has been defined, design has been locked down, you know what you're going to market with, and you need to be sure that that product you're going to market with, you have freedom to sell without the risk or with minimal risk of, for example, a patent infringement lawsuit coming your way for going to market with a product that infringes patents. A product clearance, if at that stage, would be the same thing. But earlier on in the product development timeline, a product clearance could be a landscape. It could be understanding what IP exists in the industry and in the technology area to which you're operating. A product clearance could involve you pre-clearing certain features of your product based upon maybe a company's own understanding that some of their features have a lot of IP that exists in the public domain that they're concerned about or may have already identified. Now, traditionally, we do not recommend doing a lot of your own patent analysis and whatnot, but we understand that companies are clearly, a lot of companies are clearly sophisticated in understanding patents and being able to search for patents and understanding some of what's in the public domain. So, instead of trying to prevent this sort of analysis happening, we need to be able to address it. And in those times where IP due diligence, particularly on potential patents in the public domain, are being analyzed early before a product is even defined, then product clearance takes the role of really a landscape in understanding what IP is out there that could affect the direction of innovation. So that's how we're going to differentiate it for now. But when we get to the end of this section, we're going to speak about product clearance and FTO for both sides of the table together because they are very similar in terms of the process and in terms of the expectation. So overall, a product clearance provides, again, the understanding of the IP landscape, particularly in your early stages of product development where you don't really have finished product. You're usually trying to understand how IP could affect potentially the direction of your innovation and product development. It can provide a legal foundation for non-infringement for relevant identified IP. Again, when it comes to a landscape, particularly early stages, doing a full analysis of patents in the landscape is not as necessary because you don't really know a lot of times where your product is going to innovate into and what the development is going to look like, what the design is going to look like. But at times, forming a legal foundation for non-infringement, even in early stages, may be important because you want to understand if you can develop into that space or whether or not you got to design in a different direction. And then risk management pathways. This is always part of a product clearance, is that even for identified risky IP that's out there, there are always pathways for which you can steer around it or use that IP. And you could steer around it by designing around, like we talked about. You've identified some IP. You have opportunity to design your product in a different direction. You can do that. Or maybe that direction in which to innovate and that patent is intersecting or conflicting with you is something that is a direction you need to go in. And so maybe we can look at potentially trying to acquire a license that IP to give you that freedom to pursue that technology. There are different directions to manage that risk. But the steps are really understanding what IP is out there first before understanding what risk you're willing to take and how to manage those risks. Now, product clearance is not always patents. It could be copyrights. For example, if you're dealing with software, it could be trademarks, trade dress. It could also be trade secrets. And trade secrets traditionally follows alongside patents in a way in which it deals with innovations, but it's innovations for which you wish to not publicly disclose. Think about the Coca-Cola formula, the Oreo cookie formula. Those have been trade secreted for decades and never been patented because the value of those innovations lasts beyond a patent term. And so they're kept under lock and key. So that could become part of the product clearance and part of IP due diligence in general. And then finally, one thing to keep in mind about product clearance is that it does not guarantee that a product is free from infringement. There's always a risk percentage to going to market to developing a product, particularly where there's millions of patents out there. There's obviously going to be IP that's going to be interesting to you, that could impact you in a way. But the process of analysis is to mitigate risk, to lower risk, not to eliminate risk. It's going to be almost virtually impossible to do that. We always enter the market with a certain level of risk. It's our jobs to help mitigate that risk and lower it in a way to give you comfort that you can go forward and not potentially be entering into a much more difficult world than you would have beforehand. Okay, so just real quickly, very high level product clearance studies, and FTO is the same way, and we'll get to that really quickly. Is what are the key sort of milestones as part of a product clearance? Obviously, you need to define the product, and we talked about this before. When you're in a late stage product development, you've gone through design lockdown, you're at that stage gate in your product development process. Your product is defined, so you would have a clear idea of what that product looks like because you're ready to go to market with it. Earlier on in your product development, defining a product may be to identify features which you would like to pursue, which you would like to investigate putting into your product. So defining the product may be defining sort of aspirationally what you want the product to be like, in which case that's what you'd be clearing, as opposed to a finished product, which is more so an FTO downstream. The breadth of the search. Now, there is a lot of different directions we can go in terms of what is important to the party doing the search or searching for product clearance. There are obviously technical parameters. What specific features are we looking to clear? There could be the decision of whether to look at issued patents versus published. Again, if you're looking at a landscape where you're not concerned with actual infringement allegations coming at you with a finished product going to market, you're earlier on, you may want to look at what IP is just published, not even issued yet as actual patents, because that published IP or patents could become issued patents eventually. So you may want to track that as you innovate to see what direction that IP goes. Jurisdictions matter. If you're going to go to market in certain key territories, those are maybe the markets you want to focus in on. You don't want to have a scorched earth search where you're looking at every country in the world. That search would be so expensive, and the value to it is minimal because some of those risks you're willing to accept because the likelihood of you being sued in a very small country in Central America is not going to really impact your bottom line as much. So you have to make those decisions in terms of what jurisdictions you want to look into. And there's also the factor that even certain major jurisdictions aren't really big enforcement cultures, for example. So maybe Japan isn't a huge market for you, but it's one of your top 10 markets. But Japan is not necessarily a big time enforcement culture. It's much more of a collaborative licensing culture. So maybe getting intellectual property in Japan and the cost of, or doing freedom to operate or product clearance in Japan may not be worth the cost of translating claims and looking to that in depth because you're very unlikely to enforce in Japan anyway. So these are certain factors that can impact, the scope of your search. And then finally, specific competitors. This is a big one. Maybe you're not concerned about the technology per se and clearing the technology. Maybe you're entering into a market with some major players that could really squash you. So maybe those are the players that you want to do product clearance around, not necessarily your feature specifically, your feature amongst those competitors. So these are ways you can narrow your search, broaden your search. These are different levers you can pull to get the most catered output and guidance that you need so that you can move forward. And then finally, as I talked about previously, guidance on mitigating risk. We have to provide ways in which you can lower the risk for potential issues that we've identified. And there's always directions that we can go. Obviously, you can potentially challenge those patents if you don't think you can acquire them or get a license to them or design around them. Again, you can license them. You could start to set up your own IP against those third parties. So for any reason, if those third parties were to assert against you and you could not get a license to it, do you have patents that could cover their products as well as a counterstart to come back at them? That could be a good negotiation strategy to prevent this entering into a courtroom. And then again, design around direction of innovation. You may see a patent that's problematic, and in order to mitigate risk, the company is willing to design around it and go into a different innovative direction. These are all ways that we can move to mitigate risk. Okay, next, freedom to operate. Now, I'm not going to talk too much about this. Again, I think I talked about this previously. Freedom to operate is very similar to product clearance. It's just a little bit more definable in that it is really late stage in your product development process. Your design has been locked down. You know what your product is, and you're clearing it so that you can go to market. You have freedom to go to market. So the analysis is very much the same. You're looking for third-party IP in this case, you're really looking for issued patents because issued patents are the ones that can be asserted against you. You can't assert a published application. You can assert issued patents. So we would search those. Again, looking at any sort of ongoing or threatened litigation as well. That also impacts your freedom to operate analysis. Is there a need to get more detailed analysis on certain patents to get an opinion of counsel? So what this is effectively if you've identified patents and those patents are potentially problematic, but potentially not. If you take on an outside counsel to put together an infringement or non-infringement opinion or an invalidity opinion, basically saying the patent should never have been issued in the first place, these are ways to mitigate your risk because if you have those opinions and those opinions are reasonable, then you have a reasonable basis to go to market even with the knowledge that that patent exists because you have a reasonable belief that you're not infringing it. Now, you could still get sued for it, but those opinions prevent what's called a willful infringement allegation, which could cause a tripling of the damages against you. So as part of your freedom to operate analysis, there's obviously the search and there's a generation of IP that could be problematic and there's an assessment of the real risk of that patent, of those patents. The next final step is also potentially getting opinions, actual formal opinions from outside counsel, opinions of counsel that you could rely on so you could go to market and not risk a willful infringement charge. So the FTO, again, is a very similar process to product clearance. It's just much more structured because you now have a definable product. You know you're going to market with it. And so the risk level, the risk level for you is now going up because there's no real design around possibilities at this time. And so you really are going to have to deal with those IP issues head on, whether it be through opinions or whether it be through post-grant challenges and whatnot. You're not going to be able to design around it as easily. You may be able to do it in a second version or second iteration or a product relaunch later on down the road, but that product going to market most likely can't be designed around. So that's a little bit of difference between FTO and product clearance.
So in fact, quite often the product clearance study will evolve into a freedom to operate study with the more risky patents that are located in the product clearance study.
Yeah, and then also some of the IP that you may observe during the product clearance study that was published and not issued yet, you may be monitoring through the product clearance. And by the time you get to a freedom to operate, when your product is ready for freedom to operate analysis, may be issued now. And now it becomes an actual real problem as opposed to a potential problem. It becomes a real problem because that IP has been, those patents have gone through prosecution and eventually issued as actually assertable rights. And so, yeah, absolutely. Again, this goes back to the fact that due diligence as a whole is, to a degree, an ongoing process. It's an evolving process. There are certain obvious major milestone points of due diligence or major important points of due diligence in your product development cycle or in your company life cycle, but it is an ongoing process. Okay, and so the final slide about on the defense is, okay, now let's take a look at what the expectations are from both sides of the table. Product clearance and FTO, we're going to look at this overall. So we'll tackle the investor side and then the invested side. And when I say investor, I could also mean acquirer. So from an M&A perspective, the acquirer versus the acquired, but from an investment standpoint, the investor versus the invested. So we're looking at both sides here. So from the investor standpoint or the acquirer standpoint, from the investor standpoint, obviously investment stage matters. Investment stage as well as your part in that investor cohort. So if this is a seed round and you're an angel investor and the product is going to launch in 2024, let's say it's a therapeutic, the level of product clearance in FTO is going to be very low, if any. FTO is going to be none. Product clearance is going to be very low. And the expectation on the investor side should be that. In that it's really too early to be asking that. So being realistic in terms of your expectations of that company doing the development, the investing stage matters. Also, what matters is really the development stage, which goes hand in hand with the investment stage in certain degrees and certain technologies it doesn't. You can have a pre-seed or seed company that may already have a prototype. And so development stage matters as well. And so where that product is in its development life cycle will impact you as an investor's expectation on the other side's due diligence level. So if this product is very near being completed and ready to launch, your questions about FTO or product clearance generally and FTO specifically are not investing stage specific. Even though it may be in early stages, but the product is already ready to go, your questions about FTO now become more important earlier on in that company's life cycle. So that's something to keep in mind. Also, secondary versus primary investors. A lot of times the primary investors are the one doing a lot of the diligence. Secondary investors are going to rely on that diligence, not do it themselves. So as an investor, a lot of times it depends on where you are, if you're a primary investor or not, in terms of what your expectations should be for that company that you'd be investing in. Strategy, practicality versus execution. Really, again, this goes back to being practical about when things are needed. Some investors will just say, what's the story with FTO, not understanding that in their minds what they mean by FTO is a product clearance, because they know where it is in the cycle and in the product life cycle, but maybe the terminology isn't correct. But at the end of the day, it's one thing to just execute an FTO because an investor asks you to. It's another thing to be practical in your IP strategy, and you as an investor to be reasonable in understanding that IP strategy. Again, doing an FTO on a moving target on a product that's continuing to develop is of no value to both sides, because eventually that product will settle in terms of its design, and that company will have to rerun an FTO anyway. So you as an investor wouldn't want money spent on something like that when you know that money's got to be respent again later. So the execution, blanket execution, may not even make sense in certain cases, and that you as an investor want to see a proper legal spend in the proper places and sophistication of those companies that are doing the development. And then transparency of results. We're going to talk about this a lot. It's credibility. The one thing that you're testing is the credibility of that company you're looking to invest in. And you expect transparency of results. And as we'll get to on the invested side, you should be very transparent about results, warts and all. The last thing an investor wants is to discover a skeleton in your closet, as opposed to you bringing it forward. So that is something that should be kept in mind on both sides, and that as an investor, you should expect ultimate transparency. And as invested, you should expect to provide ultimate transparency. And then how reasonable is the mitigation plan? Identifying FTO issues should not be a problem for the company doing the development. It should not be necessarily a wart if you have a reasonable mitigation plan. But at the same time, as an investor, you want to see companies present their FTO warts or issues, not hide them, and you find them, because then the credibility of the entire company goes up. But at the same time, you should also expect them to have thought about a mitigation plan for that as well. They go hand in hand. On the invested side, this goes back to something Gary said earlier. Always have a strategy in place. An IP strategy, a due diligence strategy, always have it in place, because when you get to these moments, these funding stages, if you have repeatedly looked at your strategy, then you are going to be very able to communicate it very clearly and understand exactly what that strategy is. If you're basically cramming for a test, meaning getting an IP strategy in place for these meetings, for the investor meetings, you're not going to have the comfort of really understanding why you're doing what you're doing. So as making this an ongoing process, which you repeatedly work with your outside counsel, continuously refine the process, and always have a strategy in place will equip you better for these moments. Maximize value of the study. Again, this goes back to strategy, practicality versus execution on the investor side. You don't want to do a study just because an investor is leaning into you to do one. It has to make sense. And you have to be able to reasonably professionally explain why a study doesn't make sense at this point, but why you may have a plan for doing one later. What I've experienced, particularly dealing with investors and helping out startups, is it's not necessarily that you have an answer to the FTO question. You have a plan for the FTO. It's not that you necessarily have an answer to the due diligence overall question or the mitigation plan. It's that you have a plan in place to do it. Look, I'm not doing an FTO now. I'm going to be doing it in Q3 of 2021. I'll have the mitigation plan by Q4 of 2021, because the product launch is not going to be to Q2 2022, something like that. That's a plan. Now, none of those things are going to impact what you're going to spend and what you're going to do right at this moment, but it does communicate that you have a plan and that you're smartly spending your money on intellectual property related needs or legal related needs. And again, balance investor pressure versus practicality. This all is interrelated. Investors may want to lean into you to do things, but if you have a practical reason as to why not, and is minimizing your burn, that should be just as meaningful to investors as you just spending recklessly because of investor pressure. Again, maintain credibility and proactive transparency. It goes hand in hand with what the investors should expect. To maintain credibility, you need to be transparent. You need to be able to either explain your strategy, or if you've done or executed on that strategy, explain your results, explain what you found, not hide it. And realize that defensive and offensive IP due diligence will be inquired about at certain levels. So as long as you have a strategy in place and consistently execute on it and consistently audit and check offensive and defensive issues, then you should be open to maintaining credibility by being transparent, always have a strategy in place, speaking to your mitigation plan, even if there is some potential negative, trash cans on the racetrack as you're driving along. You want to be open about that. Maintaining credibility is maybe the most important thing you can do as a company looking for an acquirer or an investor.
Yeah, I can't stress that enough. I've been on the other side of the table representing an investor where the target company was hiding the ball, and will always find it somehow. And it will always destroy the deal when that happens. So it's always best to come up with everything, including the warts, and how you're going to deal with the warts when dealing with the company. We're going to switch gears now. Jason was handling discussing the idea of looking out to third parties as to how you're building your client and how you're building your product and how you're moving forward, and how that is dictating not only your product development, but also your IP portfolio. In the second part of the presentation, the offense side, we're going to start to look inside, and specifically at the patent portfolio, although there are plenty of other things to look at as well. For example, your trade secret portfolio and how that is maintained, and keeping those records and policies in place and enforced so that you have an answer to that particular question when an investor asks it. But we're going to look at primarily the patents that you have in your own portfolio. And how you develop that portfolio is very important to how you maintain your company and how you protect your products moving forward. So the biggest thing about maintaining your patent portfolio is not only capturing your IP, but watching your claim scope and so forth as you move forward. Jason, can we move forward a slide?
Yep. Hold on. There you go.
Yeah. Some of the questions that we're going to ask during this part of the due diligence is something that you should be asking throughout your entire process of building your patent portfolio. And that is regarding the scope of the claims, the validity of the claims, and their enforceability. And the scope of the claims, we're looking at two things typically. We're looking at whether or not the claims cover your current product. Okay, and what that means is that do your claims read on that product? The other side of that is, do the claims read on a third-party product that may be a competitor of yours? Those are two good reasons to keep that particular patent and that set of claims in your portfolio and active. In order to assess the scope of the claims, we look at the file histories, we look at claim construction issues, and so forth, in order to interpret the claim language. As you know from our previous presentations, where the rubber meets the road on claims, on patents, is the claims. Those last one-sentence declarations of what the inventions are at the end of the patent define the scope that is covered by that patent. And as you might imagine, there are a lot of discussions regarding how to interpret the language that is used in that one-sentence description of the. And there are, regarding the interpretation of particular terms, because that would be important to whether or not a particular target product falls within the scope of that claim or does not fall within the scope of that claim. It also determines how broadly the claims are interpreted, whether or not those claims are valid. If there is a prior art publication that predates the earliest filing date of the patent, for example, those claims may in fact not be valid, and you can't infringe an invalid claim. The other side is enforceability. Are there any barriers to enforcement? And there we're going to look at inequitable conduct issues and any estoppel issues that might be made. Were there misleading statements made in the file history that were incorrect and were not corrected down the road? Did the inventors hold back prior art and didn't submit it to the patent office? There's a positive obligation from anybody that is involved in prosecuting the patent in front of the patent office to submit all of the art of which they are aware to the patent office. And that can get quite complicated, and through one reason or another, and sometimes through bad reasons, inventors sometimes don't submit art that they know will invalidate their claims, in which case you have inequitable conduct issues that the examiner would have found the claims invalid over that art, or that even if they didn't, that withholding it was fraud on the patent office. Those types of issues we're looking for. And we find that in the file history, in the patent attorney's records, and by talking to the patent attorney and so forth. And we also find, as part of another inequitable conduct issue, one that doesn't come up that much, but is the inventorship correct? I was analyzing a portfolio for a mid-level company that had maybe 20 to 30 patents in their portfolio. And the main founder was listed as an inventor in every single application. It turns out that when you talk to the other inventors, which we did in this case because it was a red flag, it turned out that he hadn't invented half of this. These are not research publications. These are patents, and the inventorship has to be correct. And that is one thing that if you were doing this analysis prior to talking to an investor, you would correct in the process. So, next slide.
Yeah, and I just want to add one thing to this. I want to reinforce something Gary said about the scope of the claim to define or read on your products. One of the key parts of IP due diligence we do, or at least I do for investors or acquirers, is looking at that portfolio for exactly that question. Often companies may think that volume matters, quantity matters. Well, quantity can raise issues as to credibility because let's say, for example, one company has 25 issued patents and 23 of them don't cover any of their products or even a potential competitor technology. And I have this other company that has 5 issued patents. All of them cover something key to their product or a competitor product. Well, the first thing I'm going to think is, A, they know how to spend their money, and B, they have an IP strategy. Because, 25 versus 5, that's a significantly bigger spend to get there. But what value are you getting for it? So, again, scope of the claim, covering your product or your competitor's product or whatever, having a real true value for each and every one is important as part of the IP due diligence process and a key piece of it because it speaks to credibility and it speaks to your sophistication, your strategic sense.
Okay, again, the questions that we ask are, the main question is, do the claims cover the technology that the target company is producing? That's a key question, as Jason said. You want to make sure that that product is covered by the IP, by the patents in the portfolio. Secondarily, do they cover target's technology or a competing third-party product? That can be very defensive because if you're also having trouble with the third party's own patents, potentially being asserted against you, having patents you can assert against them is also an issue. Also, in some of these deals, you have to look at the reason why this investor or this purchaser wants to acquire this company. One of the main reasons for acquiring a company is to capture the intellectual property and assert it against a competitor of the investor. In that case, you need to take a really close look at whether or not the claims have scope enough to read on that competitor's product. Because if they don't, then the company is not of the stated value to the potential purchaser. Now, you also have to look at, with the claim scope, you have to look at how the potential infringement might be made. And one thing is, you really want either the product of your company or the third-party company to be literally infringing your patent. That means that all of the claim elements are found in as they would be interpreted under standard claim construction rules. All of those elements are found in that product. And there is a doctrine of equivalence that if the element is not completely found in the product, but an equivalent kind of thing is, but that is not favored. I mean, that's not a good argument. It's a really iffy argument. There are a lot of extrinsic considerations like equities and so forth. It usually comes about when the technology has advanced and what is being used to perform a function is different than what it was before. Things that you don't want to see, although might be there, are arguments that for inducement, which is a type of infringement when the product is being advertised or a product is being sold that is advertised or with instructions for it to operate in a infringing manner. The product itself doesn't infringe, but the way it is being operated might. Okay. Now that can come up in a couple of ways, and we see it sometimes in medical devices where the actual sale of the medical device when the claims are actual method claims. In other words, they're methods of doing something. Now, the medical device itself doesn't infringe the method claim because nobody's doing anything in it, but the doctor would. Nobody wants to go sue doctors. So you need to make sure the claims read on the device itself and not a method of it's being used that would cause you to go after somebody you really don't want to go after in the marketplace. The same kind of thing happens with contributory infringement. Contributory infringement is when you sell a product that itself doesn't infringe the patents, but it has no non-infringing use and is being sold to a third party that does put it together to infringe the product. Now, that one's harder to deal with, but again, you don't want to see that. And one thing that I see quite often, because I do a lot of telecommunications work, is joint infringement. You want to look at the claims and be able to identify a single party that would infringe it. If the claims are being infringed by the combination of multiple parties acting together, that is not desirable. So, for example, in telecommunications, we would have all of these servers and computer sites and data storage sites all linked together through a network. And when you write a claim, you need to make sure that that claim is directed towards one device in that whole system, interacting with other devices in the system probably, but that one device is the one that infringes so that you can go after the manufacturer of that one device. Next slide. So again, we're going to look at validity issues when we do these studies. The validity issues, we're going to do a prior art search. If the target has not already done one, even if they have done one, we're probably going to do another one because this is really lowering the risk that we would not find material that would invalidate the claims. Because if we're going to enforce that, or we're going to make sure that the patent is valid, we want to make sure that it's valid and we're able to use it in the way we intend. Now, there's another concept that's based on 35 USC 112, which is, are the claims clear and concise? Are they written appropriately? Do they have the right structures? And so forth. A lot of that can be cleaned up through doing it ahead of time, which is why one of the big reasons why I recommend to my startup clients that we, I call it pre-package the IP portfolio, is to clear up these kinds of issues. We know if we run across a piece of prior art, we can take on actions in the patent office to clear that piece of art and get the patent cleared over. Maybe may need amending the claims again in prosecution. We can also clear up 112 issues where things are just typos and that type of thing can be cleared up. And we can also clear up some of the unenforceability issues like inequitable conduct and improper inventorship by doing post-grant processes in the patent office. The process is called supplemental examination, by the way. So we can clean up a lot of this stuff during this process, provided that you do it before your investor finds it. And doing it before your investor finds it and getting it cleaned up means you've already addressed it, you're proactive to it. Cleaning up your claims, cleaning up your portfolio, and getting rid of patents that are not working for you anymore, cleaning out that's an ongoing process that needs to continue through development of your portfolio. And it makes a tighter package and a cleaner package for potential investors down the road. Now, the other thing we look at is we look at third-party licenses. And again, that's very important. From a purchaser's standpoint, those third-party licenses will eliminate some of the problems that you had in the FTO studies that you did before. But you have to be concerned as to whether those third-party licenses are actually transferable to the new company, because quite often, for one reason or another, they are not. The other thing is to beware of exclusive licenses. Exclusive licenses have a lot of different meanings to different people, but the most extreme form of an exclusive license is almost like an assignment of rights. You get all of the rights to the patent and the right to sue, and it's very easy to remove that exclusivity in the license and lose it. I had one case where that was true, and the client didn't make the purchase because the exclusivity of the license was not valid anymore. Also, you want to make sure by looking, and it's very easy check. Look at the patent office to see if the patent is abandoned for non-payment of fees. Quite often, much of this can be corrected. License issues are tougher, but patent issues can be corrected. And you can move forward. Some can't. And you just have to deal with them in that fashion. Jason, next slide.
Yep.
Okay, sources of information. Of course, we look at the prosecuting patent attorneys' files, both foreign and domestic. We look at all the correspondence. We look at formal documents on validity and enforcement. We look at any opinions that might be there. We look at invention records originally submitted by the inventors. We look at inventors' notebooks and everything else that could impact both the scope, the validity, and the equitable conduct of the portfolio. Now, I have to say that often we don't quite get this deep into the due diligence when we're doing this. I've had due diligence projects where the purchaser was only concerned about whether or not the target actually owned the IP they claimed to own. Okay, that's a very shallow level of due diligence, but it's an important one. Next. Okay, so what are the difference here? Between your company, the invested, and the investor company? If I'm working on the investor's side, I'm going to look at quantity versus quality. I'm going to want to know what the core IP is. Sometimes, if it's a big portfolio, we will only look at 10 patents in depth in the entire portfolio. I'm going to look at understanding how the decisions are made with regard to what aspects are being patented and what are not. And I'm going to consider what part of the development stage the company is in when I do that. You know, if there's a final product that's ready to be released, I'm going to want to see patents that are pretty closely aligned with that product. And also, I'm going to look for, a full understanding of the scope of enforceability. Now, from the company standpoint, my focus is somewhat the same, but a little bit different. I'm going to look at my portfolio and correlate that with my product, correlate that with what my my product development stage is, how my inventors are investing, any third-party competitors. I'm going to be wanting to look at them and see if our IP can be made to read on that a little better. And I'm going to want to keep that portfolio rather streamlined. I'm going to want to drop patents that are no longer fulfilling any useful purpose, would dedicate those to the public, and develop more on patents that are directed towards the product. And again, you want to keep a really close eye on third-party involvement in this. Next. Now, ownership and transferability is a really big issue that we look at, and it can be it can go awry in so many ways. For example, I deal a lot with companies that are spun off from universities, for example. Well, if you've got a university professor in the mix and he's a founder of a company, quite often he's got a contract with the university that the university owns patents. So if he hasn't taken the steps to license those patents from that university, you have an ownership issue. Also, every company eventually happens. You have inventors that leave under less than optimal conditions. Then, sometimes they don't want to assign their patents, or they're not cooperating with the company at all. Sometimes, in a very early stage company, there are no employment agreements or contractor agreements that force them to assign the rights to the company. This is something that needs to be closely watched when starting the company, is to make sure that all of the founders and all of the employees have an obligation to assign their rights to patents to the company. It's very hard to go back. And absent an agreement, co-owners of patents have no accountability to each other, which makes them almost impossible to enforce. Because, if I assert the patent, then the target of that assertion can just go to my co-owner and say, okay, I'll give you, whatever, you assign your rights to me. Okay, you're done. You can't do that. So the other thing is that the small companies tend to be dynamic. You're not always sure that the people who say they can assign the rights can actually assign the rights. So you want to make sure that the power of attorney, you want to make sure that the assignment from one company to another are signed by the correct people in the chain. Next. So how do we investigate? The other thing is inventorship. As I mentioned before, inventorship is a big issue. It's sometimes hard to figure out who the inventor is. An inventor is, by definition, anyone who has contributed to any element of one of the claims. Okay. And so he has to, it's not just the person that goes and builds the device under the direction of one of the inventors. That person is not an inventor. He just built the device. On the other hand, if he added to the device and that addition gets put into the patent application, then he becomes an inventor. So you have a problem with having too many inventors, which I see quite often. You also have a problem with omitted inventors. And again, I mentioned the inventor that leaves the company under less than ideal conditions. Quite often, I've run into this a few times, the founders of the company will want to leave that inventor off the patent. That's not allowed. That person has to be included. They are an inventor. If they're left off, then it's going to be an inequitable conduct issue down the road. So in order to investigate that, we look at employment contracts. And again, there should be them, and they should have an express obligation to assignment and an express assignment of all their rights while they work for the company. If no contract exists, we have to rely on any facts and information that might support the theory that the inventors were hired to invent. That's harder to do, and it makes the IP less valuable. So we have to establish that. Often we talk to other inventors and see what they say about who were the people that involved in the inventing of these claims. Also, the other thing to look at is there any government funding involved? That can complicate your ownership and licensing rights throughout the process. Next slide. Okay, so from the two sides, we have to understand who owns the rights and whether or not the company owns all of the rights they say they own. From your side, you want to keep your assignments, make sure they're recorded with the Patent Office or other agencies, keep those records clean, and keep them up to date. And I see that we've pretty much run out of time.
Okay. Great. So I know we've used up basically all of our time, but this is quite a bit of information to go over, and we try to keep it as high level as possible. I know that there's been quite a few questions that have come in, and what we are going to do is we're going to capture those questions. If you would like to reach out to us, here's our faces and names. Feel free to reach out to Gary and I about those. Otherwise, what we can do as well is reach back out to you with answers to your questions, or at least to try to get some further clarification on questions. Some of these I think will need a little bit more clarification, but we will find one way or another to follow up. But again, here's our contact information. Feel free, if you didn't ask a question, you have one about this, feel free to follow up. Now, this presentation will be, I believe, sent out, or at least the video of this or the audio of this will be sent out for re-listening. But if there's any other questions beyond that, feel free to reach out to either one of us. And otherwise, once we get the questions captured, we'll be able to follow up with you a little later on. Okay? Thank you very much for attending. Gary, thank you very much. And I hope everyone has a good day and stay safe.